Um, Welcome to the College of Law series on how to become an international arbitration lawyer in Asia. Here with us today, we have Erika Williams, who has a lot of experience practicing arbitration in Asia and cross-border transactions and so forth. So, Erika, if you could just first of all just introduce yourself, and then I'll ask you a series of questions which will hopefully help the listeners or the viewers.
Sure. Thanks very much, James, and thanks for having me. Yes, I'm an international arbitration practitioner, senior associate at McCullough Robertson Lawyers in Brisbane. I did my degree down in Sydney and moved back up here almost 4 years ago now. And I practice in the international arbitration area.
Great. So, Erika, how did you begin your career, and how did you get your start? Just if you could just run us through.
Sure. I actually had a chance encounter with an international arbitration practitioner when I lived in Tokyo in my early 20s, and I thought her area of law sounded really interesting. I wasn't a lawyer at the time, and that inspired me to come back to Australia and get my law degree and become an arbitration practitioner. So while I was doing my degree, and then towards the end of my degree, I was fortunate enough to be given a summer clerkship.
Right. Oh, that's very impressive. So, would you say that having the experience clerking at a big international law firm helped with your arbitration career?
Absolutely. Baker McKenzie, being an international firm, obviously has that global reach, which really invites clients to approach them when they have international disputes. But at my current firm, McCullough Robertson, we are certainly very busy in the arbitration space. I think I had 2 new arbitrations come across my desk this week and finishing off an arbitration this week as well.
Oh, great. So, if you could just walk us through what a day in the life of a cross-border arbitration lawyer is like. So, what does your, say, a typical day involve? I know these days are quite unusual given the current situation, but on your normal day as an arbitration lawyer, what will you be doing?
Well, surprisingly, James, at the moment, it's business as usual. Probably a little bit less on the front end. So sometimes I advise clients when they're entering into transactions as to what sort of dispute resolution clause they should include in their contract, especially if it's an international dispute. There's usually quite a bit of negotiating about where the dispute will be seated and what will governing law be. Another front end type of advice work that I do is for clients looking to invest either in Australia or Australian clients looking to invest overseas, and advising whether they how they should structure their investment so that they can gain protection for investor state dispute settlement mechanisms under investment treaties. But the more run-of-the-mill type of work that I do daily is advising clients on how the arbitration process works. So if a client is in a spot of bother and they're thinking of issuing a notice of arbitration, they often want to know how long it will take and how much it will cost before they embark on that step. If they do decide to proceed with the formal dispute resolution process in their contract, and that is arbitration, I can assist them in drafting a notice of arbitration, or at the moment I'm actually drafting a response to a notice of arbitration that my client received, and we need to file that on Monday because it's not a public holiday in Singapore on Monday. And these are the joys of being an international arbitration practitioner. Other things I advise, I'm currently advising in relation to the appointment of an arbitrator in 2 different disputes, and that's a very important strategic decision and one of the key features of international arbitration, being able to choose who decides your dispute. And the other thing, and one thing that I'll be doing as soon as we finish this webinar, is drafting a witness statement. So we need to bed down the evidence before we file the response to the notice of arbitration, so that we know that we're putting in the best defence we can. On the administrative side, something that I don't particularly enjoy is drafting cost estimates. But as I said earlier, most clients who are in a bit of trouble would like to know how long it will take and how much it will cost before they get started with an arbitration.
Oh, that's very good. So as part of your, say, practice, do you do much business development, Erika?
Yes, I do. I am a prolific publisher. I publish articles in all sorts of journals, and this webinar is part of business development. And previously, catching up with clients or potential clients would be something that I would do, and now we have to move that into the virtual realm. So it would, I think, in the coming weeks and months, I will be having virtual coffees with clients to keep connected.
Oh, that's a very smart idea, smart alternative. We'll say in terms of, say, business development for young practitioners who's interested in arbitration, are there, say, any law organisations that perhaps might be of interest or helpful to young practitioners who may be interested in, connecting, networking with other arbitration specialists?
Yeah, absolutely. In New South Wales, the young lawyers have an international law committee. When I used to live in Sydney, I was the chair of that committee, and they do quite a bit of work in the arbitration space, including there's a Chartered Institute of Arbitrators and New South Wales Young Lawyers International Law Committee moot on international commercial arbitration. That's an annual moot, and it's something I did in my early career, and it's probably one of the best things I ever did to network with arbitrators, because you do the moot competition in front of 3 people who are arbitrators, and
Right.
in the breaks before and after the moots, you have a chance to mingle with them and find out what they work on and make a connection in that way. So, and joining in other states and territories, there would be alternative dispute resolution committees in the relevant law societies. So I'm a member of the ADR committee with the Queensland Law Society. That's certainly a way you can connect with other arbitration practitioners.
And are there any organisation at a, say, international level, maybe focusing on Asia Pacific, perhaps?
Well, yes, the Chartered Institute of Arbitrators is probably the most prominent society, I suppose you could call it. And there's an Asia Pacific branch. There's an Australian branch as part of that. And it's certainly probably one of the most well-known institutions. They have, I believe student membership is free. And then there's a small fee for the different levels of membership.
Right. Okay. So there might be something useful for anyone that's interested. Okay.
Yeah, I would recommend it.
Now, just if you could just walk us through the ins and outs of an arbitration matter and what is involved, because we might have studied arbitration at law school, but I understand it's very different to what it's in real life practice. So if you could just kind of explain that to us, would be very useful. Thank you.
Yeah, I mean, a lot of it involves what I've mentioned in what I would do in a typical day. In relation to the advisory part, as I've mentioned, there is quite a bit of negotiation over where the arbitration should be seated, even which institute should administer the arbitration. So an Australian party might want the Australian Centre for International Commercial Arbitration to administer this dispute, but the overseas party is unlikely to agree to having a dispute administered in the home institution, if you'd like to call it that. When a dispute arises, the first thing and the most important thing is also to go back to these arbitration clauses and find out where it's going to be seated. Is it going to be seated in Singapore? What are the other governing laws, Australia or England and England and Wales? And that's really how you get started on your arbitration process. It comes back to the dispute resolution clause, and that will determine how you move forward. If it is an arbitration administered by a KICA, you have to turn to the KICA rules and find out what step 1 is. Generally a notice of arbitration, but those rules will set out what you need to include in that notice, and different institutions have different levels of detail required in that first notice. If we're acting for the respondent, an arbitration matter kicks off generally when your client is served with a notice of arbitration, and the rules again will tell you how quickly you have to act to respond to that notice. Once a dispute really gets running and an arbitrator has been appointed and you've got your procedural directions for when you'll be giving evidence and things like that, you need to identify who your witnesses will be. That comes back to helping draft witness statements, identifying appropriate experts, and that's another very big strategic decision. Different experts that are typically required are, for example, a quantum expert. I've had engineering experts in construction matters, and in another matter that I'm doing where there may be allegations of forgery, I actually have a handwriting expert engaged. So it's all very interesting. There may be interlocutory processes throughout the procedure, such as applying for subpoenas or even challenging the arbitrator who's been appointed. So they can provide for a bit of a stray from the straight line path of a typical arbitration. If a matter doesn't settle, which the best resolution for the client is typically a settlement, but if it doesn't settle, preparing for and attending an arbitration hearing, which is probably the most exciting time of the whole process. Organising the logistics of something like that, especially now where we won't be meeting in person, we'll be moving to even more online types of dispute resolution. I did do a hearing last year for 4 weeks that was live streamed to our Brisbane office. The hearing was in Sydney, and we even had witnesses dialing in giving evidence from a European countries. So arbitration has always been quite embracing of technology, but these days more than ever we're moving towards that even more. Preparing for a hearing involves some really interesting preparing for cross-examination of the other party's witness. I find that work quite interesting, trying to find discrepancies in their evidence and preparing our own witnesses to be cross-examined. That's not coaching the witness, we're not allowed to do that, but just letting the witness know what they're going to experience when they're being cross-examined, and preparing them for that is a very important part.
Oh, thanks for that, Eric. That's very informative. Would you have any advice for those young practitioners who may want to specialise in arbitration? And if so, what pathway do you recommend that they start in their roles to becoming a international arbitration lawyer like yourself?
Yeah, taking any opportunity to do study in the area is really important. I was fortunate that the University of Sydney offered an international commercial arbitration course back when I did that a fair while ago now. And the Chartered Institute of Arbitrators, which I've already mentioned, they offer a diploma course in international arbitration. And for me, that sort of mimicked the arbitration course I did at university, probably because the course convener was the same person who did the university course. But it's a 9-day course where you really go through the ins and outs of arbitration, and I think that's one of the best things that I did at the beginning of my career. I was fortunate enough to do it in Kuala Lumpur in Malaysia, where the teachers of the course were truly international arbitration lawyers with a wealth of experience from many different countries. And that, again, helped with my networking in the Asia Pacific region. Another option is, I believe the College of Law has a postgraduate course in cross-border transactions and cross-border dispute resolution. So that's another opportunity there. And yeah, seeking opportunities at firms that have an arbitration practice. And it's not necessarily the bigger firms. Obviously, McCullough Robertson has a pretty thriving arbitration practice, which I'm happy to be involved with. And identifying perhaps international arbitration practitioners who you might like as a mentor.
And just talking about mentoring, do you think that is an important part to grow yourself into a lawyer? Did you have mentors when you started out?
Yeah, absolutely. I was very fortunate when I started my career that the person that I worked under at the firm I was at was very well versed in international arbitration. She was from London, and she's now actually the registrar of the London Court of International Arbitration. And I am also a member of Arbitral Women, which is a non-profit international group to promote women in arbitration. And through that group, I was assigned a mentor from Singapore, and I used to speak with her about every 3 months and try and work with her on ways I could develop my career. So definitely, if you have an opportunity to reach out and identify a mentor, it's a good thing to do.
Oh, that's very useful. I'm sure a lot of these viewers will be reaching out to you very shortly, Erika. You might be bombarded with a lot of emails.
Maybe. I mean, I do have a mentee through Arbitral Women at the moment, and she's doing her PhD in Singapore.
Wow.
And we talk about ways that she can connect with other people and progress her career as well.
Wow, that's really great. Yeah. So just moving on to the next question, Erika. So what type of person traits do you think are best suited for international arbitration practice?
One thing that's pretty important is being organised. You need to be organised in your day-to-day activities, know what you're going to be doing when, and you also need to be organised in a way that is using foresight. So you need to, say you've got a deadline approaching, you need to go back from that deadline and understand all the steps that have to happen before that. If it's drafting a witness statement, for example, you have to factor in that the witness needs to see it and return it to you, and that might happen 5 times or more or less, and then it has to go to the client for review. And so there's a lot of planning to meet the many deadlines that are about in international arbitration. And actually, time zones, it plays a big factor in that as well. I was fortunate last night that my call with Tokyo and Singapore was at 5 p.m. It could have been much later because they are obviously a lot behind us. We also have a big client in Europe who we often have calls at 5 or 6 p.m., which is very nice of them because it's only 8 a.m. for them over there. So another trait that I think is very important is tenacity, being tenacious. And I actually looked up the word because I knew that it applied, but I wanted to know what tenacious actually meant. And the definition was not readily relinquishing a position, principle, or course of action, or determined. And you really do have to be quite dedicated to the hours that are involved when there are deadlines approaching. Also needing to be flexible, and that comes again with the nature of an international practice. I have a board meeting at 9 p.m. once a month, and sometimes it gets moved to 11 p.m., which I don't particularly enjoy. And from time to time, I get conference invites for 2 or 3 o'clock in the morning, and I politely decline those ones where I can.
Yeah, oh, that's really interesting. Now, is there much, say, travel involved as an international arbitration lawyer? Is that
There used to be.
Oh, it used to be until a few weeks ago.
Yeah, that's right. Travel is a big thing, and although I must say there has been an emphasis in recent time for people to try and meet virtually wherever possible. There's a green pledge in arbitration where arbitrators pledge not to travel unless absolutely necessary, and that is from the climate change perspective, not from any sort of economic perspective. So I think arbitrators and arbitration practitioners have been quite progressive. We did used to fly around probably more often than we needed to. Mm-hmm. And now that things have changed quite drastically, I think travel will be much less of a factor. I was advising a client who wanted to know whether they should have a arbitration seated in Brisbane or if they should have it in Singapore. And when I was preparing the advice, say 2 months ago, I was advising that it's more cost effective to have it in Australia. But now that no one's going to be travelling anymore, I actually said that that's less of a factor.
So it seems like you've got to be, like you said, flexible and adapt to new circumstances.
Yeah, that's right.
So just leading on to the last question, what kind of skills do lawyers need to be a successful arbitration lawyer? Maybe soft skills, is that one of them, perhaps?
What was that one, sorry?
What about soft skills as part of, skills of being an arbitration lawyer? I know you have your technical knowledge, of course, but soft skills. Yeah.
Well, the soft skills is a lot to do with client management and your relationship with the client. That is probably the absolute most important part of someone's practice. Strategy and strategizing with the client, because sometimes you might have to deliver some difficult news if they've had an arbitration notice sent to them and they're in a bit of a pickle. Sometimes it's difficult to let them know that they might not be in the best position. And that's a soft skill that comes with time. And that's something that comes with working with more senior practitioners. I've got some amazing partners here who, when I see them dealing with the clients, I admire the way they build those relationships and deliver sometimes difficult news. But it's always good when you get good news. Some of the other skills, apart from the technical expertise, is attention to detail is absolutely imperative. The partner I work with here sits as arbitrator from time to time, and I recently reviewed an award of his that had more than 300 footnotes. Had to cross-check that against all the source documents.
Oh my goodness.
So yeah, some of the tasks aren't as glamorous as appearing at a hearing. I think I've got organised again. I must think that's a really important skill. A good memory, and that's also linked to attention to detail. If you're drafting a witness statement of one witness and then you talk to another witness and you sort of need to remember what all the witnesses are saying to make sure, or to either check that they're all saying the same thing or have alarm bells ring if something's off. So, yeah, that's a few of the sort of surrounding skills, I think, that you need to be a good arbitration practitioner.
Now, one other thing, Erika, from your experience practicing as an international arbitration lawyer, say dealing with different cultures, would you say understanding of different cultures is necessary, useful in your role?
Absolutely. even in the Asia Pacific region, there's different cultures that have different factors to what an Australian client would have. I've got a matter with Hong Kong and Chinese defendants, and that has its own challenges. Whereas I've had a matter where we had Japanese defendants, and I used to live in Tokyo, so I understand their culture much, much better. And that matter settled, and it was because of an understanding of how business is done in Japan. And same with European countries. The difference in culture between, say, France and the US is broadly diverse, even in the way they approach arbitration proceedings. So that's something that's important to understand. You will not get disclosure in France.
Right. That's really useful. So it sounds like cross-cultural understanding is very important in practicing arbitration,
Yes.
international arbitration. Well, thanks for that. Next question, Erika. So what has been the highlight of your career so far as an arbitration lawyer?
Yes, when you do get to the fun stuff and a hearing proceeds, that is an absolute highlight. A couple of years ago, I had a arbitration hearing that went for 10 weeks, and on a multi-million-dollar construction arbitration, there's about 1,000 separate claims, and I had a team of, I think there was about 5 barristers and 12 lawyers supporting me and the client through the matter. We received a very successful award, and that was one of the times when delivering the good news to the client is very satisfying after working on it for a number of years. Another highlight was, I think in 2018, I was admitted as a fellow of the Chartered Institute of Arbitrators, which means I'm accredited to sit as an arbitrator.
Right. So you just spoke about some of these matters lasting a long time. So what's to say an example of a short arbitration and a long arbitration? If you just could give us an example.
Yep. A short arbitration can be as short as 60 days.
Yep.
A long arbitration can be as long as 10 years or more.
10 years or more?
Yes.
Wow.
Yep.
Okay. So interesting.
So yeah, when clients ring and ask how long is it going to take and how much is it going to cost, you can understand why that's a very difficult question.
Yes. Oh, that's really, I didn't know it would take up to 10 years, so that's new information for me as well, Erika. Thanks for that. Next question is, how did you get your foot in the door to practice in cross-border arbitration? You kind of explained it earlier, but you could phrase.
Yeah, as I mentioned, seeking opportunities at a firm with an arbitration is a start, but that's not always easy. I think to get there, it's necessary to demonstrate a true interest and passion in the area. You can do this by, as I've mentioned, publishing on the topic. I know the AKICA review, AKICA is the Australian Centre for International Commercial Arbitration. We publish twice a year, actually looking for submissions at the moment. So another option is the Chartered Institute of Arbitrators has an annual newsletter. And then the domestic arbitration body is Resolution Institute, and they have a journal called The Arbitrator and Mediator. So that's just a few options. You can also publish in your relevant law society journal. So in New South Wales, that's the Law Society Journal. In Queensland, it's called Proctor. I've mentioned the commercial arbitration moot competition before, and as I've said, that was one of the best things I did at the beginning of my career, which leads to my last point, and that's network. And that actually applies to everyone, not just international arbitration practitioners. All lawyers should network.
And so when you say network, well, this was going to my next question. So how did you go about in networking effectively as a young lawyer? Because it's not always easy as a young lawyer going to a conference. You've got these senior practitioners around you. How do you go about in participating in networking, connecting?
Yeah, I think it starts with making a small network. And for me, that came back to the Chartered Institute of Arbitrators Moot,
Mm,
because I met, say, a dozen people
mhm.
doing that, which meant when I went to the next arbitration seminar or networking event, I knew 12 people. And then they introduced me to others, and my network grew. Um, it's That's probably the starting point. And then once you've got a few contacts, you can go to larger conferences when we start going to conferences again. And that network can just keep expanding.
And just talking about conferences, would you recommend participating as a panelist or a speaker? Would that help in terms of networking or getting your name
Oh,
out there?
absolutely. We had the benefit of the Australian Arbitration Week in Brisbane last year in November. And during that arbitration week, I had 7 speaking engagements in 3 days.
7. Wow, that's a
Yes.
lot.
It was a busy week, and we're hoping to have arbitration week in Sydney in October this year. So we'll just have to see what the environment's like in October.
Hmm. Just summing up what you've said, Erica, it sounds like one of the biggest pieces of advice for someone who wants to start out in arbitration is maybe network, publish, study diploma courses would be kind of in a nutshell of what you just said. Um, Now, is there any other business development that they could probably do instead of conferences? You talked about committees, publications. Is there anything else that you could probably advise?
Um, Becoming an international arbitration practitioner is a niche area as it is, but also having the market know if you've got any further specialisation. So I advise in investor state arbitration,
Mm,
which is quite rare in Australia. They don't come up very often, but they are coming up more prolifically, with 2 popping up this week.
mhm,
Which, yeah, so that's a very niche area.
mhm.
I had the benefit of going to an arbitration conference seminar probably only a month or 2 ago, where one of the panelists specialised in space law,
Okay.
and that was really interesting. So, in addition to being an arbitration practitioner, making yourself really stand out in the market for having a unique talent is a pretty good idea.
Mm. Well, it sounds like you've got a very niche area of practice as well, which sets you apart from the others. Um, yeah, just probably my final question for today. Do you have any tips for any lawyers who are already in arbitration practice, but who would like to advance their career into say, more of an international cross-border arbitration area, or maybe those who may want to work in Asia as an arbitration lawyer? And if so, what do they need to do, and do you have any advice for them?
Absolutely. Gaining experience in a dispute resolute in a jurisdiction such as Singapore or Hong Kong would be amazing. There's They are so busy over there. When I say over there, 2 of the arbitrations I'm doing are seated in Singapore as well. So, but working in a jurisdiction over there would give you absolutely a wealth of experience and knowledge. And it's not just Singapore, Hong Kong, but you can also go to other arbitration hubs such as Dubai, Paris, London, and New York. Those areas also have thriving arbitration institutes.
Are there any other, maybe courses, diplomas, education, arbitration courses that you might recommend for those wanting to advance in their arbitration career?
Yeah, actually, one that just came to mind is Akika runs a tribunal secretary course.
Mhm.
So I sit as tribunal secretary from time to time, which is similar to a role of a judge's associate. But there's some nuances in arbitration that it's important for a tribunal secretary to understand. So that's another option. And by doing that, you're networking by default. So aside from the College of Law cross-border alternative dispute resolution course, I have had a look at the Queen Mary University of London International Dispute Resolution Masters. Not committing to it yet, but it looks very interesting.
Right. And just finally, do you think arbitration as a practice is a growing area in law? Are there a trend? What are the current trends? Is it changing? You spoke about online arbitration process becoming more popular. If you could just kind of run us through the current trends in arbitration and whether or not you think it's a good area to get into, for younger practitioners.
Absolutely. Well, something that's really topical right now is how the courts are coping with the impact of coronavirus, and parties who are perhaps finding it challenging to progress their dispute efficiently in the court system are considering referring their disputes to arbitration instead, taking it out of the statutory system and making it a private dispute resolution process. So that's something I think we're going to see. I've seen it this week. The other one I've already mentioned is investor state arbitration. Australian claimants and foreign claimants are becoming more and more aware of the availability to bring a claim against a sovereign state if they've been wrong done by in certain situations. That is, I think, probably going to be one of the biggest increasing areas of arbitration we'll see in Australia. In Europe, it's already quite prolific, but we haven't had the need to rely on these dispute resolution mechanisms before.
Oh, thanks for that, Erika. So I think that really sums up our session for today. That was very informative, and I'm sure that all the viewers can find this useful too. So once again, thank you very much, Erika, for your time. If there's anything you want to say before you go, please do so. Just remember, Erika Williams is based in Brisbane, so if you have any questions or if you're looking for an arbitration practitioner, make sure to contact Erika. We'll have your details available if anyone wants to maybe contact you for any questions. Would that be okay, Erika?
That's great. Thanks, James.
Okay, so if you don't have anything to say, we'll end the session there.
That's it. Thanks.
Okay.
Thanks for your time.
Okay, thanks, Erika. Much appreciated.